20 मिनट में रिप्लाई थोड़ा देंगे, आपके जिस वकील साहब ने बनाया रिप्लाई, क्या नाम है इनका,
ये है साहब,
पाराशर साहब, इनकी गलती है, इनको कॉस्ट लगा देते हैं 1-2 लाख रुपए की। मैं अगर आपकी जगह होता
जी,
बन तो नहीं पाया, तो मैं ये कह
आप उससे बहुत ऊपर बच गए, बताइए।
ऊपर नहीं, मैं अपने क्लाइंट को बोलता कि इनको जल्दी से कलेक्शन दो और जाल के असेट्स जितनी जल्दी इसके पहले दो अटैच कर लो। That issue is separate now. When we applied ourselves to the fact situation,
Yes.
the situation is that there are two different players vis-a-vis you.
Yes.
One is Jayaprakash Associates Limited. They may be having a counter claim against you, saying that the liability of electricity dues has also passed on to you. No.
Yes,
I said that may be a situation for vis-a-vis JAL. Another claim is that in terms of the final scheme, you are required to bear the charges, electricity duty charges, or from the date of the closing date onwards. And now there is a dispute which is existing between you and the DISCOM. DISCOM is refusing to grant you a
various permissions, change of names, etc.
Change of names and etc. Now
I'm saying that, yes.
Yes. Now let us read section 86.
Yes.
Functions of the State Commission.
Yes. Please have my lord, the State Commission discharge the following functions, namely, please come to pay F.
F, yes.
Adjudicate upon the disputes between the licensees and generating companies, and to refer any dispute for arbitration.
Ji.
So, my lord, DISCOM is a licensee, my lord, that's correct. But I am not a generating company so far as this dispute is concerned. It is not with regard to dispute, is not with regard to any generation of power, my lord, or any charge by me. I am not a generating company, my lords.
You are a licensee.
No, I'm not licensed. DISCOM is a licensee, my lords. I am a consumer, my lords. I am, as a matter of fact, only a consumer. Because the dispute arose when I applied to become a consumer in place of JAL, my lords. They refused and they said, my lord, that you paid first the dues of the JAL. That is how the dispute arose. So your lordships will have to see that my dispute is qua consumer, my lord, as a consumer, and not as a generating company.
Right.
Because, my lord, it is not as with regard to this claim which has been made by the respondent number 1, namely the DISCOM, is not with regard to any generation of power or any liability relating to generation of power. It is a simple, my lord, dispute or a claim with regard to my becoming a consumer.
Right.
My application for purposes of availing the, my lord, say, relationship with them, my lord, as a consumer.
Yes, Mr. Advocate General. How this 86(1)(f) will be applicable? 86(1)(f), section 86(1)(f) says, adjudicate upon the disputes. This is the section which has been referred to by learned single judge.
Yes.
Now it says adjudicate upon the disputes between the licensees and generating companies and to refer any dispute for arbitration. Now, petitioner is neither a licensee nor a generating company. Then how 86(f) will be applicable? Because licensee is defined here in section 2.
Yes.
And reference to section 14. Licensee is section 2, subsection 39, means a person who has been granted a license under section 14. And section 14 deals with grant of license. The appropriate commission may on an application to transmit electricity as a transmission licensee, or to distribute electricity as a distribution licensee, or to undertake trading in electricity as an electricity trader in any area. Now, in which portion of this definition petitioner will fall? Because there is another definition of consumer.
Indeed.
You will have to satisfy this court that he is either a licensee or a generating company, so to therefore he is bound to avail the remedy under section 86(1)(f).
May I request your lordship to kindly have a document number 5056 of 21. And this was filed on 16th of February 2021.
Yes.
I make a most humble prayer, your lordship may kindly come to this reply.
Yes.
That the learned writ court has directed the appellant to approach the learned MPRC under section 86(1)(f) for adjudication of the dispute. Section so-and-so of the Electricity Act reads as thus. Then the relevant provision of that section is quoted. And
अरे पहले आप इतना बता तो दीजिए ये लाइसेंसी में आएंगे कि जनरेटिंग कंपनी में आएंगे जिसके लिए 86(1)(f).
सर यही हमने इसमें बताया है सर। हम मेरा एक निवेदन है सर, इस पे आ जाएंगे आप
मेरे रिप्लाई के मैं उसी पैराग्राफ पे आपको सीधे लेके आ जाता हूँ.
हाँ, आइए उसी पैराग्राफ पे सीधे लेकर आइए.
And I'll read the relevant portion of this paragraph.
जी.
That it is pertinent to mention that the appellant company in another matter has approached the learned MPRC in the matter of petition number so and so under section 42, read with section 86(1)(f). Read with section 42 of the Electricity Act 2003 and Rule 3 of the Electricity Rules of 2005, seeking directions against Madhya Pradesh Paschim Kshetra Vidyut Vitran Company Limited, West Discom, for its levy of additional surcharge. Then, my lord, in another petition, they approached
If they have
MPRC.
if they have
And that
wrongly
is
approached MPRC,
That is petition number 61.
we want to know
Ji.
that how this 86(1)(f) will be applicable, because it says that a dispute between a licensee and a generating company is required to be adjudicated or referred to the arbitration under section 86(1)(f). If a party does not fall in the definition of a licensee or a generating company, then how 86(1)(f) will be applicable?
My lord,
Merely because
Ji.
they have availed a remedy wrongly or rightly or under some wrong impression.
My lord, what I am respectful, they have approached MPRC, my lord, in the capacity of generating company. Here they are disputing it, that they are not generating company. So, my lord, our respectful submission is that remedy lies under section 86(1)(f). Now, this is what my respectful submission is. There are three petitions, my lord, which are referred in these paragraphs. The petition number 12 of 2020, petition number 61 of 2020, and petition number 62 of 2020. In all these three petitions, my lord, before MPRC, they have claimed themselves as a generating company, my
I
lord.
think there are two different things. Please, if I am wrong, please correct me. First issue is that they are in regard to some other plants. Now, those plants, they may be generating electricity, captive generation may be there. Okay? Their capacity as a generator will be different, and the disputes will be liable to be decided under 86(1)(f). Now, here the claim is not that they have some in-house generating capacity in the plant which has been taken over by Jayaprakash Associates Limited, and that generating is being obstructed by electricity authority, or they are not giving permission to generate electricity for captive use. What we understand for the present is that their case is, if that is their case, then the things will be different. That if electricity authorities, DISCOM, are creating any hurdles in the matter of their captive generation, then they will definitely fall under 86(1)(f). But if it is a matter in regard to transfer of connection in the name of new entity and permitting them to and supply of electricity to the new entity through their own grid, then matters will not, this is my prima facie opinion, will not fall under section 86(1)(f).
That's not
My
why
lord,
generating company.
I'll try and answer this query. My lord, in my most humble submission, my lord, if they say that they are consumer, even then, my lord, they are required to approach before the MPRC. And for that, your lordship may kindly permit me to refer section 50.
50, yes.
50. Your lordship may kindly, there is a possibility, my lord.
First of all, 50 may be it. First of all, what will happen?
Ji.
The moment this court decides that 86(1)(f) is not applicable,
Ji.
then order of the learned single judge will be set aside and matter will be remitted to the single judge to decide it afresh. Then the writ court will, appellate court will not decide that whether 50 is applicable or some other section is applicable. So first of all, there should be an understanding that 86(1)(f) is applicable or not, because there is a specific order of the learned single judge saying that they have an alternate statutory remedy under 86(1)(f).
यही है order.
ठीक है, अगर वो फाइंडिंग गलत है तो हमारे पास सिर्फ एक ही चारा है कि हम उसको क्वेश करके वापस रिमिट कर दे सिंगल जज को दोबारा कंसीडर करने के लिए। उसके अलावा रिट अपील में और कोई स्कोप नहीं है।
मेरा एक निवेदन है साहब, ये this appeal is against the decree, sir. It is not against the finding. Now, my lord, the decree is that the appellant is directed to approach learned MPRC. Now, this is the sum and substance of the judgment which is pronounced by learned single judge.
Let us see the order.
My lord, may I suggest one thing, my lord? My lord, learned MPRC may kindly be directed to frame an issue in this regard.
No.
And
MPRC is not above the High Court. It is meant, no, it is not. It is not.
Yeah.
Orders of MPRC are amenable to the writ jurisdiction.
बिल्कुल.
So we will not relegate the matter to a subordinate authority. against the order of our honorable writ court. Now, once the writ court has taken a view that the petitioner should approach under 86(1)(f),
Ji.
then the only onus on you as a advocate general and as a counsel for the electricity board is that 86(1)(f) is attracted. If it is attracted, that's the end of the matter.
My lord, I am referring few paragraphs. Therefore, my lord, I was referring few paragraphs of my written submission.
Yes.
And my lord, these paragraphs are the complete answer to the query which my lord is repeatedly making. My lord, may kindly permit me to refer these paragraphs, my lord.
Paragraph number.
सर इसमें आ जाएंगे आप पैरा 7 ऑनवर्ड में फिर आपको आग्रह करूंगा. पैरा 4, 5 ये मेरे सर आप बोलेंगे तो मैं रीड करूंगा, अदरवाइज सर these paragraphs are the complete answer to the query which my lord is making.
बताइए ना.
जी सर पैरा 4 पे
4 पढ़ लिया आपने, 5 पढ़िए.
सर एक पैरा 6 पढ़ देता हूँ साहब.
6 पढ़िए चलिए.
Page 8 में. That the appellant wrongly claims in the present case that the principal dispute in the present case is related to rejection of its name change application in 132 kV consumer connection of Bela cement manufacturing plant from Mrs. JP Bela plant to Ultratech unit Bela cement works. It is pertinent to note here that the appellant wrongly claims that it is not a generating company under the provisions of the Electricity Act. A generating company as defined under section 228. Now this is important, sir. A generating company as defined under section 228 of the Electricity Act 2003 is any company or body, corporate or association or body of individuals, whether incorporated or not, or artificial juristic person which owns or operates or maintains a generating station.
Sorry to interrupt for a minute.
Owns or operates. Ji.
Mr. Advocate General.
Ji.
The issue is that this reply 5056 is in the writ appeal. The material which was considered by
writ appeal.
Writ appeal में writ petition में जो आपने जवाब दिया उसमें आपने क्या स्टैंड लिया है, क्योंकि आपकी बात मान के रिस्पॉन्ड नंबर 1 की बात मान के उन्होंने 86(1)(f) में भेज दिया. 86(1)(f) में ये तो सब आफ्टर थॉट है. उस तारीख को 86(1)(f) एप्लीकेबल था, इतना बता दीजिए. हम अभी इनको रिमिट कर देंगे, इनको वापस भेज देंगे MPRC.
मैं सब अभी निकाल देता हूँ.
निकालिए आराम से निकालिए.
Milord, sir, if I can, Milord, sir. I'm instructed to say that in the reply affidavit which they filed before the learned single judge, no objection with regard to maintainability was raised for alternative remedy. It was orally argued, Milord. That's what I've been instructed by,
तो देख लेते हैं इनका
by the
reply.
learned counsel, Milord, who attended the hearing.
Reply देख लेते हैं. Yes. It defines a generating company. How this argument has been.
Page number 8. ये generating company under section 228 of the Electricity Act is any company or body, corporate or association or body of individuals, whether incorporated or not, or artificial juristic person which owns or operates or maintains a generating station.
How these issues.
So, sir, now this issue, your lordship may kindly appreciate, my lord, this issue is not in dispute, my lord, that they are not having captive generating plant. Your lordship may kindly appreciate. This is
I want to know that how these 3 issues which have been mentioned by a learned single judge have been dealt with in this order. What is the reasoning given to discard these 3 submissions? There was no preliminary objection. They are not a generating company. There should be a finding. Where is the appreciation of IBC and company law provisions that there is a closing date?
There is a scheme and
there is a scheme and that the change of hand was under a scheme and the clauses of the scheme are binding. Where is the consideration? Because merely having a generalistic view is different when there is a special law or a special agreement operating in the field. Now this is a very general agreement, submission. If we have to generalize, then we can also pose a question to you. On the one hand, your state says that there has to be ease of business. You are going here and there to bring investment, and those who are already working, you are creating hurdles in their working. So generally, we can also say that, but we are not supposed to make general observations, because the first question is that whether you are amenable to 86(1)(f) or not. If the answer is yes, then the things will follow.
Let me explain, Milord, say if, or should I wait for it? If you, thank you. So, let's, I'm just taking your lordship through the language of section 18(1). 86(1), my lords, F. Now, in order to attract, my lord, this section 86(1)(f), my lord, and supposedly the bar of alternative remedy, three things must exist, my lords, and three of them are independently very, very important, my lord. Three expressions are key expressions. Please have the language. Adjudicate upon the dispute. So there, here's a power. Upon the dispute. What is the dispute?
Adjudicate upon the.
Upon the dispute. So, my lord, anything under the sun or anything on the earth is not, my lord, liable to be adjudicated, my lord, by the commission. It has to be a dispute. Now, dispute, my lord, must exist between who? My lord, two parties.
Licensee and the.
Generating
That is
company.
what I asked him.
Yes. Now, my lords, if your lordships will turn to page, my lord, 53 of the learned single judge.
Yes.
The contention of the respondent number one, namely, my lord, Discom, is that the dues of the unit are to be paid by the occupier of the premises. Namely, my lord, who will be occupier? My lord, the consumer of the occupier will be premises, not as a generating company, my lords. Occupier of the premises, if the supply occupier has changed, then it is between the petition and the respondent number two to decide as to who will clear the obvious dues of the unit, but the same cannot be stand if it is merely on change of ownership of the unit. Thus, it is contended by Mr. Koro on behalf of respondent number one that the payment of dues accruable on the unit cannot be kept hanging on, etc., etc. The premises
Sorry to
under
interrupt you, that may go to the root of the virus
So,
of
my lord-
IBC, but that cannot be, unless
So,
that
my lord,
IBC is declared to be ultra virus.
Here, my lords, we are concerned with a scheme. It's not a light transfer, my lord, under a sale deed.
That's what we are.
Under a sale deed between, my lords, a seller and a purchaser.
That's what we are observing.
Yes,
That
a scheme.
Unless IBC code is set at naught, this
This
obligation.
scheme, my lord, yes. And I have judgments to say that the Supreme Court has held that the scheme is a law in rem. It applies to all because it's statutory declaration. And this is subject to conditions, what liabilities will pass on, what liabilities will not pass on. So if there is a statutory scheme which interdicts the process of transfer of, my lord, say, then these general observations shall not, my lord, arise. So my dispute is, I now in the latest affidavit filed yesterday, my lord, I must show that your lordships. My lord, it's a very interesting affidavit has been filed.
On
Please,
behalf of,
my lord, this is filed yesterday by the Discom, respondent number one, that it is pertinent to mention here that the answering respondent has never refused to change or transfer the name of the unit from JP Bela to Ultratech, and the respondent herein has only requested the appellants to fulfill the regulatory procedure. Lord, we don't know what regulatory procedure is, as laid down by MPRC. However, the appellants have failed to complete the formalities defined by MPRC. Instead of entering a tripartite agreement, the appellant and the respondent number one submitted an undertaking which is not in the proper format. So two things, my lords, that they ask us that please enter into a tripartite agreement. Discom, JP and you, that if JP does not pay, you will pay, tripartite agreement. And second, my lord, is that JP has given an undertaking, my lord, which is on record. They gave an undertaking to them that is our liability and we will pay. I must show that your lordships, my lord, at page undisputedly, my lords. Page 83.
yeah, 83.
Yes.
2017.
Now, undertaking that I am authorized person on behalf of Jayaprakash Associates Limited, that the following cases are pending in Hon'ble Highcourt, Jabalpur, writ petition number 2 pertaining to electricity duty. That's the dispute.
Look, that is all fine. First of all, counsel for the electricity board should be able to satisfy
That 86
even
1F is
86
applicable.
1F is applicable. If it is not
I'm
applicable,
indeed grateful, my lords. Yes.
there is no need to go into all these.
All
Matter is to be, order is to be set aside and matter is to be remitted for fresh consideration.
I thought your lordships would decide the matter. my lords.
My lord, in
Why-
fact,
For
why should-
2017, the my lords, it's hanging on. We
my
have
lord,
suffered immensely, my lord. Every plan is.
our contention is, my lord, our contention is, it is squarely covered under section 86 1F. This is what we are submitting, sir. For that, we have referred 3 petitions, sir.
Yes.
We have also referred this definition of generating company under section 228, sir, which says that if my lord, a company is owing a captive power plant, then also it comes within the ambit of generating company.
See, there are उनकी prayer clause में आई है writ petition में.
जी.
First dispute is that they want permission to connect to their supply line. They are
That
generating. That is one aspect.
बिल्कुल
Another aspect is to transfer the electricity connection and permit them to draw the electricity from the supply line of the DISCOM. That is second. So as far as first prayer is concerned, that dispute may be covered under section 86(1)(f).
Ji.
But second prayer to connect, you cannot deny that in the garb of pending dues of Jayaprakash Associates Limited. Because as Mr. Srivastava says, when there is a judgment which says that this scheme is statutory in nature and is binding, then that's the end of the
No,
matter.
in rem, my lords,
And-
in rem.
So, my lord, my respectful submission is, first, your lordship was kind enough to direct us, my lord, to satisfy your lordship on the point of section 86(1)(f). So, my lord, I have submitted and I have referred few paragraphs of my reply. Then, my lord, I most respectfully invite your lordship's kind attention to section 50 also,
Yes.
and few provisions of electricity supply code.
But whether section 50 was referred to before the learned single judge, if it was not,
Ji,
we are
uh,
sitting here
Yes,
in appeal.
your lordship is right. Your lordship is right.
If section 50 was not there, then there is no point. When the matter is remitted to the single judge,
See,
you can raise
your
all these
lordship is right.
objections, 50,
Your lordship is right.
81.
Your lordship is right.
लिखिएगा. Mr. Srivastava, with the consent of the parties, remitting it. I'll not write consent, but I'll write your arguments and remit this matter to the single judge. लिखिएगा.
My lord, in which case, my lords, may I make a, sorry, first
26, your
time bound,
time bound.
time bound, my lords, and my interim applications are, because nothing is happening, my lords. I'm not getting connection, I'm not able to
Make
increase my
it a
demand.
time bound thing.
Laptop.
Make it time bound. लिखिएगा. This, ठीक है. This writ appeal is fine.
Lord, my learned friend wants to, if you lord gives
please,
permission, my lord, because he,
Much obliged. Because the problem is this, Milods. All my applications which I make, Milods, for receiving power or exporting my power from my generating stations which are there inside the, all these issues, Milods, are being rejected on the basis that we don't recognize you as a consumer because there are certain past dues which are required to be paid, Milods. I'm unable to take power even from the DISCOM, which is apart from whatever is sanctioned as on date. If I want to increase my power, I'm unable to take it, Milods. They have also rejected my application for disconnection from the grid, village.
anyway.
So I'm unable to operate.
So we are very hard pressed, my lord, that's all he
ये
wanted.
लोड बढ़ गया है.
We are very hard pressed.
ये लोड बढ़ गया. आप थोड़ा correct statement दीजिए.
We are very hard pressed, my lord.
Writ appeal is filed, being aggrieved of order dated 8/12/2020, passed in writ petition number 15889 of 2020. Namely, between Ultratech, amongst Ultratech Cement Limited and another, and Madhya Pradesh Purv Kshetra Vidyut Vitran Company and others. Full stop. Several issues have been raised, but the main issue is that learned single judge has remitted the parties to avail alternate statutory remedy as contained in section 86 within bracket 1, another bracket small f of the Electricity Act 2003. Full stop. Next one. It is submitted that alternate remedy is not available to the petitioner because neither it is a licensee nor a generating company, and therefore petitioner is not entitled to invoke jurisdiction of the State Electricity Regulatory Commission in terms of the provisions contained in section 86 within bracket 1, another bracket f of the Act of 2003. Full stop. Next one. It is pointed out that three requirements are to be essentially fulfilled. Namely, there should be a dispute. Second, the dispute should be between a licensee and a generating company, and then it can be adjudicated by MP State Electricity Regulatory Commission or may be referred to in arbitration. Full stop. And in that context, neither petitioner is a generating company because it is not seeking any relief in the form in its capacity as a generating company, but is only seeking a relief in the capacity of a consumer. And therefore, this court is of the opinion that provisions of section 86(1)(f) will not be applicable. Therefore, impugned order is set aside. Matter is remitted to learned single judge to decide the controversy within a within a period of 30 days from the date of receipt of copy of this order. Full stop. Parties are registry is directed to list this case before the learned single judge on 13th February 2025, for which no separate notice will be required, and then learned single judge is requested to, if possible, complete the proceedings on or before 13th March 2025.
Absolutely.
And my lord, I have a respect.
And any
All these-
observation made herein will not come in the way of adjudication of the writ petition.
Yeah.
Lord, sir.
My lord, all questions may be
But
kept,
these
my lord,
pleadings are
all
complete,
questions may be left open, my lord.
तो सभी तो left open है 86 1F को छोड़ के.
But the pleadings are all complete. Well, let them not go on.
नहीं,
for
नहीं,
the
नहीं,
Pleadings are complete.
उसमें लिखना pleadings are complete. Honorable single judge is requested to hear the arguments and decide the case on its merits expeditious.
And one more
Sir,
request, my lord.
sir, pleadings are not complete. We'll raise objection with regard to section 50 also, sir. That we'll do within time, sir. Section,
Now jurisdiction is over, my lord. Now the
Jurisdiction
jurisdiction
है.
point is over.
yes, sir, section 50 point.
Jurisdiction,
नहीं,
no,
juris-
there will be no
Your
end to
lordship,
this, my lord.
section
otherwise.
50 point is still there.
चलिए बताइएगा वहां जाके बताइए.
हाँ, वही
भाई-
उसी के लिए.
एक चीज अच्छी हो गई ना मुझे सुनना है ना इनको सुनना है.
बस आप इतना उसमें ऑब्जर्वेशन हो जाए.
नहीं नहीं नहीं.
ये
Lords, only one request was there, my lords. Since your lordships are pleased to record my submissions, I was referring to the latest judgment of Must.
हाँ मस्तरम वाला जजमेंट एक से लिख ले.
The matter is covered by.
Supreme Court in CA/1662/2024-UTCL versus Mastaram decided on 20/9/2024 has
Concluded.
concluded that the closing date is the reference date and the scheme is akin to law and is operational in rem.
my lord,
And the liability does not pass on to the ultratech prior to. Prior to
अब
that is-
ये
And नहीं बस ये हमने
Submission
and
वाला है,
the scheme being operational.
हमारे भी
the
सबमिशन है सर.
Rights and liabilities of the parties will be
covered.
subject to governed by the scheme. That's
सर हमारा भी सबमिशन है सर कि हमारा रिटर्न सर चूंकि रिट कोर्ट में नहीं था तो सर दैट रिटर्न विल फाइल सर एंड विल क्योंकि इसमें आ गया प्लीडिंग्स आर कंप्लीट या तो सर रिट अपील का रिप्लाई जी
क्यों नहीं था रिटर्न है ना आपका
मेरिट है.
रिटर्न है ना आपका रिटर्न रिप्लाई है ना आपका.
सर सेक्शन 50 का जो ऑब्जेक्शन
अरे तो आप पीसमील में रिप्लाई थोड़ा ना देंगे आपके जिस वकील साहब ने बनाया रिप्लाई क्या नाम है इनका
ये है सर
ऋत्विक पाराशर साहब इनकी गलती है इनको कॉस्ट लगा देते हैं 1-2 लाख रुपए की.
नहीं सर सेक्शन 50 हमारा कंटेंशन तो साहब
पीसमील में नहीं होता रिप्लाई पीसमील में.
सर सेक्शन 50 का ऑब्जेक्शन रेज कर सकते हैं कब
ठीक है आप करिए सारे ऑब्जेक्शन रेज करिए.
सारे ऑब्जेक्शंस तो ओरली रेज किए थे ना आपने पहले भी तो
करिएगा.
राइटिंग में तो कुछ
क्या
था ही
बचा?
नहीं.
क्वेश्चन ऑफ लॉ दैट कैन बी रेज्ड एट एनी स्टेज एंड इवन
इनका केस
वर्बली इट कैन बी रेज्ड
आपका केस तो ऑटोमेटिकली डिसाइड हो गया. आपकी रिट अपील भी हो गई डिसाइड.
Lord, that's one important thing. The pendency of the other rate appeal will not come in the way of the.
हाँ,
Will not come in the way of
हाँ, it is
the-
clarified that pendency of WA 00728/2021 will not come in the way of disposal of the writ petitions. एक चीज और लिख लीजिएगा इनके submission में that generalized observations made by honorable single judge dehors the scheme which is having force of law and is operational in rem cannot supersede the statutory scheme.
My lord, at least this much, my lord, liberty, my lord, to raise our, my lord, we may be granted liberty to raise at least objection in the light of section 50.
मैं अगर आपकी जगह होता
जी
बन तो नहीं पाया. ओ, मैं ये कह
आप उससे बहुत ऊपर बन गए बताइए.
ऊपर नहीं जनरल का स्थान बहुत ऊपर है साहब को भी मालूम है साहब भी रहे इसके एडवोकेट. The thing is कि मैं अपने क्लाइंट को बोलता कि इनको जल्दी से करेक्शन दो और जाल के असेट्स जितनी जल्दी इसके पहले
जल्दी
खुद को अटैच कर लो. ठीक है
रेट अपील में देखिए जाल के फेवर में स्टे भी नहीं है तब भी प्रोसीड नहीं किया
ठीक है,
उनके खिलाफ रिकवरी के लिए.
ठीक है ठीक है.
ठीक
आई
है
एम वेरी ग्रेटफुल my lord, your lordship.
Unofficially he was a former employee of MPBs.
That's correct. Lord, sir, I'm very grateful that your lordship accommodated me. my lord,
Yes,
sir.
and this writ appeal इतना 60.2 वाली 1 वाली we listed separately for hearing. इसमें पंडित साहब का नाम डाल दीजिए. चलिए अगला केस.
Great.
विजय कुमार लखेड़ा